Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I have to give you a legal disclaimer. And the legal disclaimer is that this podcast isn't legal advice. While I have to say this because the Florida Bar Association tells me I have to say this, I will tell you that nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. There are quite a lot of hot topics in the disability insurance world that I've been getting calls about. And today I'm going to be discussing these hot topics. And they primarily revolve around work issues. The work issue is, should you quit your job or should you apply for your short-term and long-term disability benefits now? What's the strategy behind this? Is quitting a good move or a bad move? What you might want to do instead of quitting? What you have to do before you change jobs to protect yourself from financial ruin? And what you need to do if you have pre-existing medical conditions before you make the decision to terminate your employment. We're also going to talk about what you should do if your employer tells you not to file for short and long-term disability benefits and just apply for your Social Security benefits, and the real truth about your human resources department. And then lastly, I'm going to talk about the 3 things you have to do before you apply for short and long-term disability benefits. These are questions that I'm getting every day in and day out, primarily because of the great resignation that's going on and people deciding whether or not they want to move on to what appears to be a greener pasture, when in fact it can be a financial disaster and a medical disaster by making the wrong decision. Let's take a break. Welcome back to Winning Isn't Easy. Now, we've talked about why you shouldn't quit or why you shouldn't let your employer convince you to reduce your hours to less than 30 hours if you're having trouble at work. But here's, I think, the most important part of our podcast today, and that is the 3 things you have to do before you apply for short or long-term disability benefits. Before you play any game, you get out the directions so you can learn the rules of the game and how to play the game. That's what you need to do before you stop work and apply for your short or long-term disability benefits. And in my view, there are 3 things that you should do before you stop work and apply for benefits. So what are they? Number 1, ask your employer for a copy of the disability policy or plan. You go to the HR department and you ask for a copy of the policy or plan, or better yet, you can get it online. Now, your employer has to legally provide you with a copy of the policy or the plan. And if they don't, they can be sued under the ERISA statute. That allows a judge to fine them every day if they don't produce the policy or plan, and even order them to pay your lawyer's fee for getting those benefits. You don't have to tell them why you want the documents. You've got a legal right to know the terms of the policy or plan. So don't be embarrassed, don't be afraid, and don't be ashamed to ask. If you're pressed for an answer, tell them you're thinking about buying a private disability policy and the agent wants to see a copy of your current policy or plan that the employer's provided. That explanation should shut them up. 2, read that policy or plan from cover to cover and outline it. Yeah, I know it sounds like a homework assignment. And guess what? It is. There is no uniform disability policy or plan. Each is different. You should read the policy or plan cover to cover. Read it a second time and then outline it. So what are you looking for as you're reading it and outlining it? These are the things that you're looking for. You want to know, what's the definition of disability in the policy or plan? It's not just you can't work, you have to meet the policy definition of disability. What's the definition of your own occupation? Is it your job as you're performing it for the employer? Is it your job as it's performed in the national economy? Or is it your job or occupation is defined by the Dictionary of Occupational Titles that hasn't been updated in 30 or 40 years? What's the definition of any occupation? In other words, what do you have to prove to get your benefits from the time the definition of disability changes from own occupation to any occupation to the end of the policy? And that could be to age 65 or 67. You also need to know, when does that definition change from own occupation to any occupation? Because the games are going to play and start to be played prior to that definition change. You need to know whether there are any policy limitations for subjective medical conditions like fibromyalgia, migraines, or body pain. You need to know whether or not there is any policy limitation for mental nervous conditions. It's what I call the Monty Python wafer-thin contribution definition of mental nervous conditions. Well, what do I mean? What I mean is some policies will say if your disability is caused or contributed to, regardless of how thin that contribution might be, your benefits are limited to just 2 years. And that means that you've got to do some planning, if you will, and how you are, what treatment you're getting and what you're telling your doctors. And certainly just before this definition, disability changes, and this definition of mental nervous conditions becomes applicable. Now, you also need to understand whether you have to apply for your Social Security disability benefits. You need to understand, are your benefits going to be reduced by the receipt of Social Security disability benefits you or your family members get because of your disability? Is it going to be reduced by workers' compensation benefits, PIP benefits, the proceeds of a personal injury or a malpractice case, the withdrawal of your pension benefits, or even other disability insurance? You got to understand, if I reduce my hours, am I going to lose my coverage? Do I have a residual claim or do I have a total claim? In other words, can I reduce my, once I filed my claim, reduce my hours and have a requisite loss of income that will allow me to file a residual claim? Or does my policy not even provide for residual benefits? I got to be totally disabled. And you need to understand whether or not your policy or plan requires that you and your employer attempt a workplace modification, and what's required and when it needs to be done. So knowing the answer to all those questions will help you understand what you need to prove to get your benefits, how much you're going to get, how long you're going to get them, and potentially the claims process. Now, what's the third thing you need to do? Go get your medical records and review those records. You have the burden to prove you're disabled and unable to perform the material and substantial duties of your occupation, as how those terms are defined by the policy. The disability policy carrier or the plan administrator is going to get a copy of your medical records. You need to know what's in them before you stop work and apply for benefits. And I have this issue right now with a physician who did not look at his medical records before he stopped work. And his physician did a pretty bad job about explaining his symptoms. He didn't do a very good job of explaining his functionality at home or how those symptoms impacted his ability to practice medicine. He didn't specifically identify what the material and substantial duties of his occupation were, and then tie his medical difficulties to problems he was having doing that. The medical records are going to be examined to see what the diagnosis is, what the restrictions and limitations are, and whether those restrictions and limitations are supported by objective medical findings. They're going to be looking to see whether or not you've got problems with your employer, because what they're going to say is your disability is a result of your HR problems or problems with your supervisors or coworkers. That has nothing to do with the disability. It's an employment issue. They're going to look to see whether or not you've attempted to work with or without accommodations or reduced hours, and what the impact of that was on your ability to work. And they're also going to be looking to see whether you're exaggerating your problems or symptoms. In other words, you need to know what's in your medical records, and you need to know whether your doctor supports your claim, and whether your doctor is going to fill out forms that are going to be required as part of the disability claims process. And if not, you're going to have to find another doctor who supports your claim and fill out forms. So if you have stopped working and only to find out your doctor doesn't support your claim, you're screwed. So what happens is you really don't want to let these three things destroy your claim and your financial security. You need to take the time to do these things and make an intelligent decision about applying for your disability benefits, and certainly making an intelligent decision about not quitting or being part of the great resignation and moving on. These kinds of decisions can destroy your financial security and your ability to provide for yourself and your family and to get medical coverage. So don't make poor decisions. I hope you've enjoyed this week's episode of Winning Isn't Easy. If you've liked this episode, consider sharing that episode with others, leave a review, and please subscribe to this podcast. That way you're going to be notified every time one of our great episodes comes out. I hope you've enjoyed today's episode. Thanks.